Good morning and welcome to the December 6th sitting of the Massachusetts Appeals Court. My name is Catherine Hand. It is my very great pleasure to be sitting with Justices Rachel Hershfang and Robert Brennan today. We have 5 cases on our list. We anticipate taking a morning break after the 3rd case. The ground rules for today, with which you may be familiar, include the fact that each side will have a total of 15 minutes to argue. There is no rebuttal in the appeals court. You'll notice when you reach the podium a set of 3 lights. The first light will show green for about 13 and a half minutes. When it gets to about 90 seconds, the light will turn yellow. And when the light turns red, I'd ask that you stop unless you're finishing your answer, in which case please finish your answer and then stop. We have read your briefs. We have read the accompanying papers. We are familiar with the background of your case. So I'd ask you to feel free to jump right into your argument. And I would remind counsel that if there is any portion of your case that is impounded or partially impounded, that you be aware of that fact and remain within the confines of the applicable order. So with that, I'll call the first case today, Commonwealth versus PEKINGS AZIWUNG, 22P1119. Counsel.
Good morning, Your Honors. If it pleases the Court, my name is Richard Hartquist. I have the privilege of representing PEKINGS AZIWUNG. Your Honor, this is a difficult case because it's agreed that consensual sex occurred only minutes before the allegation. And in that, I have formulated an ineffective assistance argument that centers mostly on the saliva and the report of the DNA that happened in this case. Now,
Hartquist, not to get you before you start rolling.
it's okay.
Can you point to anyone in the record the actual where it says saliva? I read that report several times, and I don't see saliva anywhere. So
Yeah,
do we know it's saliva versus any other sort of a fluid?
I'm happy to help you with that, Your Honor. Thank you for asking. Number one, a stipulation was entered that there was saliva. Obviously a stipulation, both parties signed it, there was saliva inside the condom. Number two, on the stand during trial, day 4, and I can give an exact page, Your Honor, the expert on the stand stated, the question was there saliva in the condom? Expert said, yes, there was. So it's definitive. It's a stipulation, and the expert states it.
Thank you.
And before you pick up again, if I could ask another question, I'm not clear on what the significance of the fact that there was saliva inside the condom, how that establishes whether the second incident of vaginal intercourse was consensual or not. I'm not sure how that places it on the timeline.
Normally it wouldn't. However, this is a rare case where the defendant testified on his own behalf, right? And the defendant said that when he came out of the restroom after the first consensual intercourse, there was a second intercourse that began with oral. Victim states, alleged victim obviously by the defendant, states that she was wrapped up in a blanket, he rolled her over and engaged. Defendant states that's not how it happened at all. I came out, we engaged orally, and then we had consensual, and I videoed it. Okay? This saliva is completely consistent with the story offered by the defendant and completely inconsistent with the story offered by the alleged victim.
I disagree that it's completely inconsistent with the alleged victim's story. Why couldn't it be possible that the saliva inside the condom resulted from the first consensual sex, even under his view, the defendant's view of the evidence?
Well, I'd argue first inferences, right? Second, I'd argue that I think it's agreed by both parties that the defendant goes into the bathroom after consensual sex, takes a condom off, and then washes himself and comes back out. Okay, that's at least the testimony. There's no contrary testimony to that.
Well, that's his testimony, right?
Correct. Nothing
And
contrary.
she wasn't in the bathroom with him,
Correct.
and she didn't testify about what he did in the bathroom,
I agree.
and she didn't testify about whether or not he left the bedroom wearing a condom or not.
I don't believe so. No, she didn't testify that he left the bathroom wearing a condom, but I think that the facts are pretty clear that he was wearing a condom during both incidents.
Mr. Hartquist, is there anything that you can offer by way of evidence that was proffered at any point that would indicate that simply, if we're going with your theory, simply by going in and cleaning himself off, that he removed every shred of DNA from himself before he put on, if we call it the second condom?
That's such a good question because it actually funnels into the ineffective assistance of counsel argument, right? I'm arguing that there should have been an expert on the defense side. The Commonwealth hires an expert. Often the defense counsel's first idea is to hire my own expert. Well, if we had an expert, we'd have known that, right? This is an ineffective assistance argument. He doesn't argue the saliva at all. Okay, he doesn't open with it, doesn't close with it. There's one question in the whole trial that establishes it besides a stipulation, right? So why not get an expert and have the expert get on the stand and say, well, if he went in and washed himself off, there'd be no saliva on him, and his story would then be more likely true than not true. I'm not disagreeing with Judge Hershfang.
Okay.
You can, it's okay.
But in the motion for new trial, wouldn't it have been helpful for the judge to have an affidavit from a chemist that said, if we had this, we could have at least developed this theory if given the opportunity. But there's nothing of that sort when the motion for new trial, when the motion judge looks at the motion.
I don't mean to interrupt.
No, that's
Respectfully, Your Honor, like, doesn't common sense dictate that if you get an expert, the expert will be able to say this or will be able to say not this, right? The expert also has my notes say the expert can discuss the implications and the impact of saliva inside the condom, right? That's why we need the expert, and that's why we have ineffective assistance. Without that expert, how about should counsel have engaged an expert? We have no evidence that counsel even engaged an expert to explore this. This seems like the most important fact in the whole trial to me, and I can't imagine how it will go ignored. And that's part of, Safarian says, better work, full and complete investigation, right? And it spills over into the text messages and the video, right? The defense counsel learns 2 days before trial that the video is allegedly from the second encounter, not from the first encounter.
So right. Could I ask, I'm sorry to interrupt you on this, but was there am I remembering incorrectly that there was a request for funds for an expert from the defense?
Right, and none was retained.
And we know that how?
Well, I know that because I contacted counsel.
Do we have an affidavit of counsel in this case?
We do not.
Is there a reason that we don't?
I approached counsel and counsel declined to sign an affidavit. And I fashioned it in many different ways.
And did you include an affidavit to that effect in the record?
I believe not.
Okay. I'm sorry to have interrupted your train of thought.
No, your privilege. So, Your Honors, wrapping the ineffective assistance counsel argument up is not just the saliva issue, right? It's the investigation leading to discussion on the video on the day of trial, right? A prior misrepresentation by counsel that it was the first incident, met with his client 2 days before trial and learned that it was the second incident.
How do we know that your client didn't change his story on the eve of trial when he thought, oh, the first one's not going so well, so let me throw this at you? Well, it was the second incident that we had videotaped.
A fair question, Your Honor, and it seems like the motivation to fabricate is strong. However, counsel put it on the record. I just talked to him and I just learned of it. He didn't say, he didn't say it. He didn't say that he changed his story. He told me initially it was the first, but now it's the second. He only said it's the second.
And even with that, as the motion judge noted, the evidence got in, both sides argued one way versus the other, correct?
It did come in, yes.
And the trial
jury got the video.
Honors argued, well, that's the second, that's the after the post-bathroom, if you will, versus the pre-bathroom. And the Commonwealth offered, nope, the other way around.
Right, and I did argue post versus pre-bathroom, and you obviously read the transcript of the hearing, and that's my effort to state it artfully. Again, further investigation, expert witness, and I bring up the video, the text messages, and the timestamps as well, right? So we have a video, but the timestamps are never explored, and that could have been relevant. We have text messages that clearly show, and admittedly, alleged victim says on the stand, I was very upset with him. I learned that he had been cheating on me, and none of those text messages came in. Those could have been helpful.
I'm sorry, I'm doing it again, and I apologize, but the videotape timestamp, how would that have assisted?
Well, we could have created a timeline, right? Timelining is so important in almost every trial. We could have created a timeline of when they engaged, possibly when he went to the bathroom. Remember, even the alleged victim says she was looking at cell phones during the time he was in the bathroom. We may have times. A timestamp could have established when he came out of the bathroom. and that would have explained to us when the video was taken.
But
and
it
how
also
relevant
could have
that video is.
established that the video reflected the first consensual encounter, right?
I apologize, I didn't hear that.
Sorry, I'm all froggy this morning. I said it also could have established that the video was from the initial consensual encounter, right? I mean, we just don't know because both the Commonwealth and the defendant were deprived of the opportunity to develop forensic evidence about the video.
But isn't the fact that we don't know illustrative of the fact that defense counsel should have found out so that we did know?
You know, defense counsel filed a motion based on the representation that the video represented the first encounter, the consensual encounter. And only 2 days before trial, according to him, learned or was told by his client that actually it was a second encounter. I think it's difficult from the perspective of this record to understand what communications there were between counsel and the defendant before that, you know, Sunday before trial discussion.
The way it's presented by counsel to the trial judge, who castigated counsel for making this assertion that it was a second, counsel said he didn't know. I didn't realize it. And I think that illustrates ineffective. So in my brief, I've included 5 or so reasons why I'm positing that there was ineffective assistance of counsel and that something better would have created a better result, right? I'm not required to prove that he would have been found not guilty, only that we could have got a better result. I have 4 minutes and 36 seconds left, and if I could switch to waiver, if the court doesn't have any more questions.
Please, and I actually had a question on that before you go there. So if I'm not mistaken, 2 signed waivers and 3 colloquies, and your client brought up the release. How is that involuntary under any understanding of that term?
My research of the case law says it's absolutely involuntary to tell a client, I'm going to let you go if you agree to waive the 12-person jury and take a 6.
Is that what happened? Because as I read it, Judge Drexler's in the middle of a colloquy and your client says, well, can I get released? He says, well, look, if you go into trial, essentially, he'll accommodate your client by letting him be out at trial. It was unusual circumstances, to be sure.
Right, and COVID created the situation. I'm not criticizing the judge by any means. I would never do that. However, the judge very clearly states on the record on 2 occasions, right, once in October, once in November, and it's in my brief, exactly what's said. He says, I will consider allowing you to go home if you agree to waive the jury. And we'll be able to try your case quicker. And I don't understand how it's relevant or how a case could be tried more quickly during this time because he goes from 12 to 6.
Because you couldn't get 12,
if
right?
he's waiting for a 12, he's going to have to wait a year.
Right. Well, no, because there were no 12-person juries.
Understood.
So that's the reason. I can give you 6 next week. I can give you 12. I have no idea when. It could be never.
And my client responds, and it's in the transcript, I'll take the 12, and I'd like to get some home confinement instead of some jail, right? And look, Your Honor, everyone knows, okay, if a judge looks at you and says, this looks like a good case for a bench trial, then it's a good case for a bench trial, all right? If the judge says, look, I'll consider letting you go if you take a 6-person jury, this is kind of an old case, then the defendant's going to say, I'll take the 6-person jury. And all the case law that I cite says it's coercion. And the case law is very adamant about the fact that, and I didn't know this before I researched it, right? A 6-person jury is simply not a 12-person jury. It's a waiver because 12-person juries are more effective. 12-person juries are more diverse, right? We have a black defendant and a white victim, and that matters to defense attorneys. So we get 6 jurors, they're all white.
Does the record show that?
Yes.
Okay.
Okay.
You make an argument that your client had a constitutional right to a 12-person jury.
Absolutely.
That's undecided in Massachusetts?
I cite U.S. versus Mitchell. No, I cited federal law to establish that, and I do not cite Massachusetts case law on that. But I think the Supreme Court of the United States controls in this, right? And it says anything other than a 12-person jury is a waiver. There was a case where there was 11 jurors because one juror got sick or passed away or something like that. The conviction was overturned because you need to have 12. 12 is diverse. And The fact has also been established that 12-person juries have more opportunity to interact, more opportunity to discuss, more opportunity to have diverse views.
Right, and a 15-person jury would have even more opportunities to interact and discuss and have diverse views, but there's no constitutional right. So I'm trying to focus on the constitutional.
Respect, Your Honor, by your logic, a 100-person jury would also be better, right?
But boy, would that be hard to sit.
But it's been established that 12's our number, and 6 is not our number. It's a petite jury, right? It's
Right, but Mr.
Well,
Hartquist,
they're all a petty jury.
12 has been established statutorily, not constitutionally. You'll agree with that. And when the Constitution was written, I don't think they had 12-person juries.
Your Honor, I think maybe Ballou versus Georgia, 435 U.S. 223, a 1978 case. I believe that establishes that a 12-person jury is not a statutory right, but a constitutional right. Now, I wouldn't swear on that, but I did read that case recently, and I feel that that establishes the position. Look, this young man on record asked for a 12-person jury and asked to be released. In response to that, the judge said, I'll consider releasing you if you take a 6-person jury. The judge had every right and every logical means to, or reason to say that because of the COVID pandemic. However, he was deprived of a right that he had asked for at that time. And I'll wrap. Thank you very much, Your Honors. I appreciate your time.
Thank you very much. Attorney Burns?
Thank you. Good morning, Your Honors. May it please the Court, Kayla Burns for the Commonwealth, and here with me I have the trial prosecutor, ADA Marcos. The Commonwealth asked this Court to affirm the Superior Court's denial of the defendant's motion for a new trial and affirm his conviction in this case. And I'll begin where counsel began as well, with the DNA evidence in this case. And I would just like to state to the Court, nowhere in the record does it definitively say that the material that was found within the condom was the victim's saliva. I think the report makes very clear, and it does not clearly state that it was saliva that was found inside the condom. And I believe on cross-examination, when the forensic expert did testify, she did state that there was cellular material inside the condom, but she was unable to specify what the source of that material was. So I think the record in no way makes clear that the victim's saliva was what was found in the condom. And I think and I think the motion judge also states this in her decision, even if that fact was established, which it's not in this case, even if it was, that doesn't go to the central issue of consent in this case. And I think correctly so, the motion judge states that this evidence could cut either way for both cases in this case. And I don't think, contrary to what the defendant says, that this would be powerful evidence in support of his argument in this case. Again, both the victim and the defendant in this case testified that the victim did perform oral sex on the defendant. That's not disputed in this case. And as I said, even if this was the victim's saliva that was in the condom, it would support both parties' versions of events. And ultimately, again, it did not go to the ultimate issue in this case, which was consent as to this second intercourse that occurred. And I think even if it was established that the victim's saliva was what was in the condom, that doesn't go to the heart of the consent issue in this case. And I think it's also important to note that there was substantial other evidence in this case of the defendant's guilt, which included the text messages that he sent to the victim in direct response to her accusations that he had raped her. And he responded to those direct accusations with apologies and saying that the devil had made him do it. And in addition to those text messages, there's also a video of the defendant showing up at the victim's house where he was crying and begging for her parents for forgiveness. So I think even, again, putting aside the fact that it is not established that it was the victim's saliva in this condom, that, again, it didn't go to the ultimate issue in this case, and there was substantial other evidence of the defendant's guilt in this case.
Could you address for a moment the argument regarding North Shore Counseling Center records, where it appears to me that there was a Bishop Fuller motion on made initially, then there was a motion to reconsider?
Correct.
And then a third motion was filed on the same records with the attorney requesting no action.
And I think in the interim there was new counsel. I think new counsel came in, and new counsel was the one who asked for no motion to be, no action to be taken on the motion. And I think perhaps that, and I think it's important to note that prior to these motions being filed, the defendant had obtained substantial amounts of medical records from the victim's mental health treatment at this point. He had received documents from, I believe, I get a little confused with the name, but I believe he had received records from Quadra and Bay Ridge already. And I think this is a point the motion judge also makes and that I argue in my brief. Perhaps after seeing all of those records, he made a strategic decision that perhaps there would have been information that would not have been helpful to him in these records. So I think it could be viewed as a strategic choice at that point, having viewed all of the medical records that he already had, that he was not going to pursue further obtaining these records. And if I could just briefly go back to the DNA issue and how that relates to whether a medical expert would have been pertinent in this case. I think as Judge Brennan pointed out, we have no affidavit from any expert that says that they could even test for some of the things that the defendant is now saying that they could have tested for, let alone that they would be able to testify to that in court. We have no affidavits whatsoever from any expert that would opine that they would be able to testify to any of that information. And again, calling a witness on this issue would have been a strategic decision in this case. And again, defendant does not specify here how a medical expert could have elaborated on this DNA evidence, which again, as I pointed out, is not conclusive, certainly, based on the record and even in the stipulation that the parties agreed to, and that was read to the jury. And I guess next I'll address the claims that defense counsel failed to investigate in this case. I think a full view of the record here shows that defense counsel thoroughly marshaled the evidence that he had and presented a substantial defense for the defendant, so much so that he did secure an acquittal on the strangulation charge in this case. And I think in specifically looking at the video recording in this case, even though counsel only belatedly indicated that he was going to argue that this video encapsulated the intercourse at issue in this case. I think it's important to note this video was still shown to the jury, regardless of this belated indication to the court and to the Commonwealth. This video was shown to the jury. They were able to view it. And the defense counsel forcefully argued that no rape occurred during this recording to the jury. And again, the Commonwealth argued otherwise. So again, I'm not sure how any further investigation earlier would have changed anything for his defense, even if this had been discovered or relayed to the court earlier. So I think that's very important to note that the jury still had this video and defense counsel was still able to make this argument. And I think that's the...
What about the argument that if the video had, if counsel had earlier discovered that the video purportedly represented the purportedly non-consensual encounter, a timeline could have been created?
You know, perhaps there could have been timestamps on the video that the parties could have used, but I think in light of the testimony as well that's in this case, there was really no timeline established at all based on the testimony that both parties provided. So I'm not sure that having timestamps on the video alone would have been enough to establish a timeline for the whole evening. And I think that would have... I think that would have been a hard argument, again, in light of the fact that there was no testimony, I believe, from either party as to the specific time that they arrived at the house, as to what time any of these events were allegedly occurring.
But there was testimony, right, about the order of operations, for example, without respect to the actual chronological moment in time that, you know, there was a consensual encounter, then there was a break during which the parties were separate and he was on his phone looking at text messages, maybe sending text messages. So isn't it possible that a forensic examination, or frankly just looking at the phone, which I understand was still the same phone at the time of trial, right?
I believe so, Your Honor.
Could have established, like, well, he was texting at X o'clock and this video was taken at, you know, X minus 5 or X plus 10 o'clock. So that leads to at least a possible conclusion that this video represents either the first or the second encounter.
Respectfully, Your Honor, I'm not sure even if we had information as to say when he was texting or when the video was shown, I'm not sure that would conclusively establish a timeline, especially where the victim and the defendant's testimony differed as to perhaps not the first portion of the evening, but certainly as to the second portion of the evening. I think there was discrepancy in their testimony as to when the defendant was in the bathroom, when he came back. And perhaps having any of the cell phone information may have either supported his version of events, or perhaps it would have not supported his version of events. And I think perhaps at this point I think based on the testimony, and I don't think that having found this out earlier would have been able to conclusively establish a timeline that would have perhaps been helpful to the defense. And I think it's important to view this under the ineffective assistance of counsel standard as well, and is that if he had done something, would it have made a material difference to his defense? And I think even if we had some of that information, again, as I stated, I don't think it would have been enough to conclusively establish a timeline for that evening, especially where the parties differed as to who was where and when that evening.
Are you aware of anywhere in the record that might show the entire duration of the interaction? In other words, not the entire interaction, but the first sexual intercourse, bathroom, second, which has been determined to be non-consensual intercourse, what that time frame was? It 3 minutes, a half an hour, or is there nothing in there?
My memory is that the consensual portion of the evening lasted about 10 to 15 minutes. I believe that there is testimony to that effect, that the first portion of the evening was roughly 10 to 15 minutes. And then I think from there is where the victim and the defendant's testimony differs as to who was where, when someone came back, when the rape occurred. I don't think that timeline is clear in the record, but I do know that I believe there's testimony that the first portion of the night was 10 to 15 minutes. And I guess I'll move on to the issue of waiver in this case. And I would first like to say that in Massachusetts there is not a constitutional right to a 12-person jury. In the Commonwealth, it is a common law tradition that a jury is of 12 individuals. But there is no case law in Massachusetts or within the Massachusetts Declaration of Rights that states there is a constitutional right to a 12-person jury, and I think the motion judge aptly went through all the case law on that issue. But even if we were to assume that this, and that the defendant had a right to this 12-person jury, I think the record makes equally clear and readily apparent that the defendant himself elected to make this decision to go forward with a 6-person jury. And I think what's important, too, is to note the circumstances. And again, these were weird circumstances. This was in the midst of the COVID-19 pandemic. There were no 12-person juries that were occurring. And I think it's important that we note that the defendant was the first person who brought up, and I think he's the one who indicated his intent that he wanted to move forward with a jury of 6. And I think only after the defendant brought that up was when the judge started saying on the record that he would consider releasing the defendant should he choose to go forward with the 6-person jury. And I think the record also makes plainly clear why the judge was making clear that he was only considering this. This defendant made very clear that he was not a suitable candidate for conditions of release. He had multiple instances where he had issues with his GPS. He was not complying. He was ordered to report to court on a Monday morning, and he failed to do so. There were multiple instances where this judge attempted to accommodate this defendant, and this defendant at multiple turns chose not to comply with his conditions of release.
Would it make a difference at all if the defendant subjectively believed, here I am, I'm stuck in the Essex house, there's a lot of COVID floating around here, I just need to get myself out of here, whatever it takes. And the only way I'm getting out is if I go with this 6-person instead of the 12-person jury, subjectively. Would that make any difference to the analysis at all? I'm not sure that there's a record of that, but to the extent there was, hypothetically.
I don't think it would, Your Honor, especially where we have the 3 colloquies that were conducted. We have 2 written waivers that the defendant himself signed and that defense counsel signed and said that he reviewed all of these things with the defendant. The defendant said multiple times in open court that he was willingly, with no force or no coercion, was willingly making this decision. And this didn't happen once, not twice, it happened 3 times. And he also signed that waiver waiver twice that explicitly stated and that he went over this with his counsel as well. So I think even if, and there isn't, but even if there was some sort of evidence that subjectively that's what the defendant was thinking, I think when we look at the record and the evidence, it makes plainly clear that he knew the implications of going forward with a jury of 6, and he willingly chose to do that in order to have his case tried sooner. And if there are no further questions, the Commonwealth will rest on its brief.
Thank you.
Thank you, Your Honors.
Thank you both for your excellent briefing and compelling arguments. The matter is submitted.
Thank you very much, Your Honor. Appreciate your time. Nice to see you.
Same as Harquist.
Okay, our next case, Commonwealth versus Anthony Sherlock, 22P0007.
May it please the
Counsel,
Court.
good morning. Keeping in mind that the case is partially impounded.
Yes, Your Honor.
Thank you. Whenever you're ready.
May it please the Court. Good morning, Your Honors. Jennifer Peterson here today on behalf of Anthony Sherlock. This case turned on the credibility of the complainant nearly exclusively, Your Honors. And defendant argued at trial and continues to argue that the allegations that the complainant was held captive from January 27th to February 1st, vaginally, anally, orally raped multiple times daily without the use of a condom is inconsistent with the physical findings here, and that the evidence in general in this case is fraught with inconsistencies. The complainant left voluntarily. She admitted to a consensual sexual relationship with Mr. Sherlock. She said she chose to leave an inpatient psychiatric unit, and he chose to come with her. And when they were out together, they decided that they were going to stay in a homeless shelter when they left. And when she was confronted with her mother, when her mother came looking for her, she refused to go with her mother, to go home. And the police were called even, and the mother was the one who was threatened to be arrested. She chose to stay with Mr. Sherlock, even in the safety of a mother who was armed with a knife and the police there.
Attorney, excuse me 1 second. Mm-hmm. Could I ask you to just jump for a moment, and I apologize if I'm knocking you off track here, to the underwear issue. Is there anywhere or anything in the record, can you point to anything that tells us how long she was wearing the underwear, last time the underwear was changed, whether and to what extent it was washed at any recent period of time, given the lifestyle that she was engaged in at the time?
No, Your Honor, there's nothing there, and I believe that there was a suggestion that there be a voir dire held to answer these sorts of questions.
So that theoretically the DNA that was from 4 different sources could have been from month or months earlier, could have been from weeks earlier, could have been, we have no idea, no way of telling.
Well, that would be speculation, which is why I think it would be important to have the analyst come in and the criminalist come in that could better educate the counsel and potentially jurors as to, you know, how long this sort of biological material stays in fabric and stays in a body cavity as opposed to on a body cavity, because we know that the evidence showed that the last claimed sexual interaction between the complainant and the defendant was about 15 hours or so. No, excuse me, 27 hours, 28 hours. It was 11 a.m. on the first, and on the second, it was about 2:30 p.m. when she had the SANE exam done. And that SANE exam had, even though there were 14 different slides taken, vaginal, anal, perianum, and oral swabs and smears, none of them turned up positive for DNA, despite allegations of repeated rapes without a condom.
So can I just pause you on the, I want to circle back to sort of a follow-on to Justice Brennan's question. Where in the record can we find a factual basis for the conclusions that you would like us to draw about the meaning of the scientific evidence? I've looked at the lab reports. I see that they're in the record. What I don't see in the record, and what the trial judge did not have before her, was anything that explains the significance of that scientific evidence.
And I think defense counsel argued that it is the absence of the evidence that's probative here, the absence of evidence in these circumstances. And had he been allowed to introduce the absence, and in the law we frequently allow the absence of evidence, the absence of a denial is probative of guilt, right? If you fail to deny something that you ordinarily would deny. The defense counsel wanted to say that the absence of DNA under the circumstances that are being alleged by the Commonwealth and by this complainant, those physical conditions are inconsistent with the allegations.
And so what is the factual basis for that argument? Is it that just we all ought to know that under the circumstances the Commonwealth is alleging that there would be DNA found? I'm trying to figure out how to bridge the gap between the argument and the facts that were in evidence.
Well, I would suggest the fact that the Commonwealth got to admit evidence of the examination and evidence that there was that he raped her and ejaculated in her vagina, anus, and mouth, and that was in the medical records. But what wasn't in the medical records is that, any kind of results from the DNA, those were kept from the jurors, even though, and as far as bridging the gap, I think the sane protocols in Massachusetts say that if the last incident took place, if the incident took place within 5 days of the report, that a test should be done, suggesting that DNA material would, quite possibly be found. And the literature is clear.
Here's where you're losing me, and I want you to help me find this thread. You're citing to the sane protocols, which are not evidentiary rules and are not rulings of the Supreme Judicial Court or even this court, and you're saying suggest that DNA would be found. And what I'm asking is, how do we know that a juror, why is it within the understanding of the average juror that DNA might, should, ought to, could possibly be found on a garment 27 hours after a sexual encounter?
Well, I'm not suggesting not only a garment, but on the complainant herself. So how would we suggest that? That's what the experts are there for, and I believe
right. And where in this record is there evidence of what these experts would have said on that point? I've seen the reports. I know what they found, but the piece that I'm looking for is the piece where they explain how what they found relates to the probability that these encounters happened in some number of hours before they did their examination.
Well, I would suggest that defense counsel requested that he be allowed to do a voir dire of the criminalist and the analyst and possibly the complainant. And there was also, it seemed that the DA also said if the court is contemplating allowing in this DNA evidence, that we would agree that this voir dire be held. And the court did not allow the voir dire. So, the attorney made the attempt to tell the court what he anticipated proving, that he anticipated offering the criminalist and offering the analyst in an attempt to show that the biological material degrades, but to ask questions that that would inform the court and potentially inform the jurors, that biological material is expected to stay in a body cavity, in certain conditions for a certain period of time, or that, how long after a shower, how does that affect it? He
also had sought funds and been allowed funds, right, to retain an expert.
Yes, I believe he did. And I'm not certain what happened with that expert, if she wasn't available on the date, or whether he believed that the information could be better brought out with the analyst or the criminalist, or if we needed additional funds. I'm not certain what why trial counsel didn't call that particular expert, but he did summons the analyst and the criminalist who work for the Mass State Police, who are ordinarily called by the Commonwealth. So
There's no motion for a new trial where that sort of a record could have been developed, though, correct?
no, there has not been a motion for new trial, although one can be done at any time. And if
Fair
the
enough.
court believes that that would be helpful,
Nope,
I'm
not
sure
saying
Mr.
that.
Sherlock would be pleased to go ahead with one.
Certainly
No
not
free
suggesting that,
advice
just-
today.
Just confirming, just confirming. Thank you, though.
Okay. And as far as, I know the judge relied on Mattei, for saying that the admission of these inconclusive results, because that's what they were, inconclusive results. We say that they bring up a reasonable doubt. This case is all about reasonable doubt and whether or not Mr. Sherlock is able to prove reasonable doubt. And clearly the jurors had issues with the complainant's testimony. They did not find him guilty of kidnapping, even though she says she was held captive. I mean, when the police came to her, she was in a library downstairs using computers, and he was on a totally different floor. They were both in the Cambridge Public Library, and the police were there at her mother's request, not at her request. She had an opportunity to tell the police that she'd been sexually assaulted or anything. She didn't. She at some point after about an hour said he hit her. And her head was bothering her, and she was examined. She was taken to the hospital. She never said anything at the hospital. And then even the following day, she said to her, and she was alone too. Earlier that morning, she was alone looking for a pregnancy test in a clinic. She didn't tell the nurse or anything.
The jury had all that, though, right?
The jury did have all that.
And it's really a credibility question.
It is a credibility question. But had the jury also known that there was DNA testing, and even if they didn't know that there were 4 profiles, all of which were inconclusive, even if they knew that there was no biological material found in this complainant, because they know she went to the hospital.
So can I just, on the 4 profiles, how is that conceivably not rape shield? I've looked at the argument. I've tried to figure it several different ways. How is that not rape shield?
Rape shield, I would suggest, Your Honor, rape shield needs to give way to a constitutional right to present a defense. And,
Well, when? I mean, otherwise there'd be no rape shield, because if you could use it any time you need to present a defense, you just put in all the evidence, right?
Well, I disagree.
In this
because
specific situation, what is the exception to the rape shield law that would have permitted this evidence of the 4 DNA sources to come before this jury?
Well, it would be helpful if Fayweather, which I cite in the brief, says if it would be helpful for a jury in determining whether the complainant is telling the truth.
So just
And
general credibility?
It's 100% credibility, because this is a situation where if she's really being held captive for, 5 days, 7 days, being raped repeatedly by Mr. Sherlock, then why would there be other biological material? And the judge says something about, it would be inconceivable of her to have had sex with 4 men after she was taken home. And we're not suggesting that at all. I agree that it would be inconceivable. I think what it goes to show is that she wasn't being held captive, which jurors obviously believe because they found him not guilty of kidnapping, but it also shows that she was at liberty. Her credibility is what we're looking at here. Is what she's saying, what happened here, is it credible?
But how do you make that argument when the jury found him not guilty of the kidnapping charge? I mean, in other words, your client won on that credibility battle in the court. Presumably, we don't know exactly why the jury does anything ever, but one might presume that the jury found the complainant not credible on the kidnapping point already. So what more do you get with respect to her credibility on being held hostage by adding in this DNA evidence?
I think what we get is the fact that the medical records, her testimony, repeatedly say, he ejaculated into her. Repeatedly, into all of her orifices, repeatedly. And then all of a sudden, but none of his DNA is shown anywhere. So I think the Commonwealth gets to make the argument that he ejaculated into her over and over and over again, and he doesn't get to say, but there's no DNA. So his way of confronting her statements, the medical records, all of it would be to say, But there's no, it's inconclusive.
But that's a different argument than, and by the way, there's DNA from 4 other people.
Yeah, yes, but even if the judge had done that and parsed that out, and even if the judge had said, you know what, I'm not going to let you bring in that there were evidence of 4, but I will let you bring in that the evidence was inconclusive and that there was absolutely nothing on any of these swabs or any of the smears. There was absolutely nothing on those. So even if she had let everything but the fact that there were 4 male profiles, even if she had just let the inconclusiveness in, that probably would have been enough to kind of get him over that hump and at least to raise reasonable doubt in the minds of the jurors. Because I think that would have been a way of solving this problem, and to let the criminalists testify and let the analysts testify.
How do we know what they would have said?
We don't know what they would have said because they weren't permitted to do, there was no voir dire permitted. And, you know, when I was talking about Mattei before and the admission of inconclusive results, the judge cites to that, but that was a case where the statistics were unfair to the defendant, and where the court said that non-exclusion, and there was testimony that the defendant couldn't be excluded, that was analogous to a match, and that's what they were worried about. But they cite in Mattei a case called Matthews, where inconclusive DNA test is allowed, and the defendant it was allowed for the defendant to challenge the integrity of the investigation and the use of forensics. So, you know, I would point the
But
court
there was
to
no
that.
Bowdoin defense here, right?
Excuse me?
There was no Bowdoin defense in this case.
There was a Bowdoin issue raised. Yes, there was a Bowdoin issue raised, and at the end of trial, and the court refused to give a Bowdoin instruction.
Maybe I'm remembering a different case, but I have a note that on transcript 2, page 46, defense counsel says, this is a Bowdoin defense, but it looked to me actually like an erroneous transcription. I think it actually, if you read the rest of the statement, it was probably this isn't a Bowdoin defense.
I'm not certain of that, but I know a Bowdoin instruction was requested and denied because, and part of the grounds were that they didn't even try to go get any DNA from the basement or anything. The police officer went about a week before trial, which was significant, like a couple of years after the event happened. Nobody went to the basement and investigated. So there was a question about Bowdoin here in general.
Any further questions?
Thank you, Your Honors.
Thank you. And Attorney Walsh.
Thank you. Good morning. May it please the Court. My name is Emily Walsh. I'm an Assistant District Attorney from Middlesex on behalf of the Commonwealth. The trial judge properly denied the defendant's motion in limine to admit DNA testing where the defendant did not make a factual or scientific showing that the evidence was relevant. The defendant did not lay a foundation to show how the absence of the defendant's biological material on the victim's body or to show how the inconclusive DNA from her underwear are probative of any issue in the
Do you agree that the judge denied defense counsel's request for voir dire, at least on the issue of the absence of DNA?
The defendant, at the end of the motion in limine hearing, the prosecutor said, if Your Honor is remotely inclined to allow this, I would request a voir dire.
So the defendant didn't request a voir dire?
The defendant said, I support that request. I mean, it wasn't really his request, but in any event, the judge need not hold the voir dire hearing. The decision to hold a voir dire hearing is a discretionary decision, and here the judge fulfilled her gatekeeping function in the motion in limine, where the defendant offered no information whatsoever as to the expert's opinion and the scientific foundation for that opinion. A separate hearing was not necessary.
So you're suggesting if the attorney had just said, by way of offer of proof, I expect the chemist or the criminalist to come in and say, well, you'd expect to see some DNA if there was all sorts of bodily fluids flying around here.
I think that if the defendant had and as noted by Justice Hershfang, that the defense did retain an expert or requested funds for an expert to review the lab reports to, quote, understand the full significance of these test results and to prepare a full defense. The expert that the defendant requested funds for the motion said that among her specialties is the study of retention and transfer of biological fluid on clothing. She seemed like an on-point expert to consult, and no affidavit or opinion from that expert was presented at the motion in limine. To answer your question more directly, had that expert offered an affidavit that's saying you would absolutely expect within this period of time, even after a shower, there's no question that there would be biological evidence in the defendant's body cavities and on her underwear, yes. That would have been a very different situation than the situation that we were in here.
And your position is then that it was within the judge's discretion to say, I don't even want to hear from the criminalist? That makes sense to me.
The motion in limine was an opportunity for the defendant to present foundation for the testimony he was proposing. When he was asked at the October 7th hearing on the motion in limine for the scientific foundation for offering the evidence, this is on page 40 of the motion in limine hearing, his response was, the witnesses that I've named are scientists and I expect they are able to testify. If he had provided a summary of the science, of the opinion, then I think he would have gotten over that bar to get a voir dire hearing, and they would have probed the expert's opinion more thoroughly. But where he offered literally nothing and said only that they are scientists and he expected them to testify, that is not sufficient to require the judge to hold a voir dire hearing, and it was within, her discretion to decline to have a hearing. The motion was reviewed, there was a hearing on it and a written decision, and the defendant offered nothing to support any scientific theory showing how this evidence would be relevant.
So your argument, I just want to make sure I'm following, your argument is not that these proffered witnesses would not have been competent to testify or could not have provided information.
We have no idea.
Right. It was a failure of proof by the defendant at the motion stage.
I wouldn't say that it's both. So, I mean, the prosecutor in the motion in limine hearing says, you know, I've had conversations with the lab employees with similar cases, and they've said, based on very similar facts, that there's nothing here to offer an opinion on, that they wouldn't be able to offer the court anything helpful. So the defense counsel did not lay a foundation, but it is a definite question whether he could have. It seems very likely. My inference from the fact that the specialist, the expert on retention and transfer of biological fluid, my inference that she did not submit an affidavit or an opinion is perhaps that what she was able to offer was not something the defense attorney thought would be helpful.
I don't think that's an unreasonable inference, but obviously that's not part of what's before us. And similarly, I read the statements from the ADA as well, but I don't think, you know, those are statements of counsel, so those are also not a factual basis on which the judge could make the ruling. And reading Mate, which I'm probably mispronouncing, it seems that similar specialists did testify in that case as to the meaning of inconclusive test results.
So, but this was both the negative swabs and the inconclusive test results, and I would also assert that it is a very, very fact-specific inquiry on when inconclusive test results are probative of anything. And as Justice Brennan pointed out, the inconclusive mixed DNA was for underwear that could have been worn for any period of time, and we have no evidence, and she was homeless with limited access to laundry. And also, the testimony was that they had had consensual sex for days, somewhat reducing the probative value of the presence or absence of his biological material on her body or in her underwear. If there are no further questions on the first issue. Regarding the closing, the prosecutor's closing argument was a fair response to the defendant's closing. The prosecutor did not refer to facts not supported by the evidence. She did not argue that the victim was credible simply because she testified or state any personal knowledge of truthfulness of the witness. Rather, she pointed to reasons why the witness's testimony should be believed, which was a fair response to the defendant's attack on the victim's credibility.
Can I just say that I thought that the chart that you put on page 23 of the brief was very helpful.
Thank
so
you.
Thank you for doing that. I love when council really think about what's going to help us navigate the record and come up with creative stuff. So do that.
Thank you. If there are no further questions, I'd rest on my brief.
Thank you. Thank you both for your excellent briefs, and your argument was very helpful. The case is submitted. The third case on our list, Commonwealth versus John E. Cassidy, is 23P0517. Good morning. If you'll just wait
Good
for
morning,
1 minute.
Justices. May I begin?
Just hold on for 1 minute until the lights are ready. Is that? Okay, when you're ready. Thanks.
Good morning, Justice. Thank you for hearing me today. Thank you for hearing my argument. I think it's a very important time in our country, as well as Massachusetts, for not just for myself, but for all legal gun owners. I think there is a lot going on, and there's some ambiguity about who can own, who cannot own, and there's a lot of things coming down from the Supreme Court that are maybe muddle the waters or change in the varying state jurisdictions. And I will say with the recent Bruin case that says you can carry a firearm, kind of a hyperbolic presentation of that would be, well, how far can you carry it? Can you carry a firearm from Texas to Massachusetts? Can you have that? Because I stand here today advocating for legal owners to be able to carry firearms, because that's what I did, is I am a licensed firearm owner. My entire life I abided by the laws, and I carried my gun from Texas to Massachusetts to attend law school, and now I'm a convicted felon and I have no right. And I think that is, I think that's an egregious way to treat a constitutional right in a state that there was a lot of tea dumped in a harbor that's a walk from here. There was 50,000 private citizens that marched on Lexington and Concord when the British regulars tried to disarm this state of magazine powders and cannons. So this state is the start of the revolution and the start of gun ownership and the whole constitutional right.
Mr. Cassidy, can I ask you just a
100%.
hopefully simple question? I read your brief on this case, and I read your brief on the case that was decided by a different panel of this court in 2022. And they look pretty identical to me, other than add Bruin. Am I missing something, or is that essentially what we're dealing with?
I agree.
You're requesting the same relief, you're complaining about the same issues, and almost verbatim or quotation, and I don't mean to be disrespectful, but cut and paste perhaps, without cutting a few lines, it's the same exact brief. Am I wrong?
No, sir, I agree. I agree. The change would be.
So the only thing that this panel is here to decide is whether Bruin, the New York Rifle and Gun versus Bruin, in any way impacts our Supreme Judicial Courts or this Court of Appeals decision on your case. Because we're not dealing with broader Lexington and Concord life issues, it seems.
I would agree with you, but I would play anti-hero to what you just said. I think that's a completely simplification. I would say, unless I forget, I think a case before Judge Hershfang said something about how do you get me there, how do you bridge the gap. So I would agree with you. If you're going to bridge the gap to affirm my rights and overturn my convictions, then I'm going to say yes to you. but I've had enough experience to say that, man, I'm at a low percentage here. But I would say cautiously and not disrespectfully, I don't care about Goddardo and I don't care about Bruin. What I would tell you is Morin v. Liver is what holds this court. That's a federal first district court that went from district, that then went to the federal appeals court, and then on October 3rd, SCOTUS kicked it back and said, go look at Bruin. But I would say Morin v. Liver is the case that holds. I don't care about Goddardo and I don't care about Bruin unless they help me. Then I do care about them. But there's some good stuff in there. But Morin v. Liver is exactly what happened to me. And I think it might be inappropriate to submit it, but as
But
a segue.
in that case, the defendant was not a law-abiding citizen.
He was not a law-abiding citizen.
And your concern is with respect to the means-ends test, the strict
Exactly.
right? And didn't the Supreme Court in Bruin say we don't do that anymore on guns? We look at historical, but solely focused on the history.
And if we're following that, so it's solely focused on the history. For 200 years in Massachusetts, you could own what I owned. And in 1976, Angelo v. Jackson came out, and that changed it a little bit, but didn't affect my large capacities, didn't affect my assault rifle, didn't affect my 9mm. And then you go 20 years later to 1998, and that's when the law changed in Massachusetts, and it changed for me. So if you're going to go on Bruin, you're going to have to side with me and overturn my convictions, because historically Massachusetts has not regulated the arms that threw me in prison.
Sir, did not our Supreme Judicial Court already address that question and
Angelo v. Jackson?
sadly for you, say that the types of weapons that you had were not, based on the history, the types of weapons that have been permitted, that they were not typically possessed by law-abiding citizens, and that they were dangerous and unusual weapons. Didn't our SJC say that?
Your SJC probably did say that, and that's wrong under federal law.
Okay.
So historically, I just ran through this historically, respectfully.
Yep.
They're not dangerous and unusual weapons. That is not an AK-47. That is not a weapon that holds more than 10. Dangerous and unusual standard comes from the U.S. v. Miller case, and that's talking about a sawed-off shotgun. You go look at that case, that guy was in the back seat of a vehicle with a barrel so short that he could go from the back seat passenger to the back seat right, and it would make no sense that you wouldn't know that was a sawed-off shotgun, because he's moving it behind the vehicle, and a shotgun barrel for hunting purposes is going to be probably 26.5 or maybe 20 inches, not 3 inches. Barrel. And so I will say that is a dangerous and unusual weapon. A dangerous and unusual would be a stiletto gun, not an AK-47. If I go along with your reasoning, sir, the SJC has ruled. So explain why.
We can't overrule them. Three of us can't.
I agree.
Overrule
I agree. 100%. I agree.
How the system works around here.
If you look at the record, let's go look at the approved large capacity weapons and the approved rosters. There's dangerous and unusual weapons on there. So if those dangerous and unusual weapons on there, then my sister's brief is relying on the SJC because that's the case law, but the SJC has to be mistaken because there's weapons more dangerous on there than what I possessed, and there's weapons there's firearms that hold larger than 10 bullets all over that. So how can something be dangerous and unusual, but then at the same time it's licensed and regulated in mass? That would be getting everything you want and nothing that you don't want. And so I am a law-abiding legal citizen. I never broke any licensing laws my entire life.
Well, but Mr. Cassidy, you were not actually licensed in Massachusetts. Whether you might, I think it's not before us whether you could have gotten licensed in Massachusetts. But when you possessed those weapons in Massachusetts, you had no Massachusetts license to do that. Do I have that right?
I never paid for a Massachusetts license. That's correct, ma'am.
Okay.
And
is there anything in Bruin that you can point us to that says or implies that your Texas license is still good in Massachusetts or constitutes a Massachusetts license?
Well, I would say the Second Amendment is my license. It's presumptively lawful. That's exactly what Bruin says. So my ownership inside my home is presumptively lawful. For Massachusetts to require me to have a carry license when I want to have the firearms inside my home would be requiring something that I don't want. And so Massachusetts, under your thing, then Massachusetts gets to decide how I exercise my right. Well, that sounds like a privilege. That doesn't sound like a right. So if Bruin says that it's presumptively lawful, firearm ownership, then it's presumptively lawful inside my home. And so I might need a license and I might have to pay the taxes for the license, but the whole bigger picture of having a license is so that criminals don't get guns. And I'm not advocating for criminals. I'm advocating for legal ownership of firearms. And so that criminals don't get guns, that's why there's a licensing structure in place. So the practical matter of a license is that you've been trained, you are familiar, you don't have any drug addictions or a background in criminal. Well, I meet all that, and so does Texas.
Would you agree with me that it's not only criminals, it's sometimes folks with mental health issues?
100%.
Sometimes folks with substance use issues that don't rise to the level of criminal behavior. There's all
100%.
sorts of other factors that a licensing authority looks at, right?
Exactly what Heller
says. That's why
says.
we need people to go to the licensing authority, it would seem, unless I'm missing something, other than just having a broad-based, as you say, right to just have whatever gun you want whenever you want it.
Which would be presumptively lawful.
Okay.
So inside my home, it's presumptively lawful. It's sacred there. And so I think that at some point, the state cannot hang their hat on, oh, we can have a licensing scheme. Well, you can't have a licensing scheme that goes into a lawful gun owner's house and then throws them in prison. I came here to go to law school, and I ended up at Walpole for owning guns that are legal in mass, that are on the approved roster, and what I did was timely fail to fill out a paperwork and pay taxes on my license. There was nothing that disbarred me from owning those firearms. Those firearms are okay to be owned in Massachusetts. So because I didn't pay the taxes and file paperwork, not only do I go to prison, at the same time, and again, I'm rehashing what happened in 2020, now I'm banned for the rest of my life? There's just no way. The 14th Amendment, isn't that why it exists? Is so that you have equal protection of the law? Like you have due process? That is the problem. And again, if I can say one thing now in 5 minutes, might not be properly before the sport, but going back to the DA's brief about dangerous and unusual, that is the lion's share of their brief. Dangerous and unusual is addressed in Heller, and I would just cite you guys to do not look through the contemporary lens that the district attorney's office is trying to get you to look through. That's a contemporary lens. The Supreme Court spoke about a contemporary lens by the SJC in the Catano case. You can't look through that lens and say, oh, this is what we're going to do. That's Bruin says it is presumptively lawful and dangerous and unusual. It is and unusual. These weapons aren't unusual. Are firearms dangerous? Absolutely. I'm not saying that firearms aren't dangerous. Their one purpose is to kill, right? Whether that's an animal or a person, they are dangerous, but these weapons aren't unusual. And so I have an active, and this is for the court if I can submit it, this is an active non-resident hunting license that the state has issued to me. This is active. I bought this summer. So I would submit this to the court or ask the DA to explain whether I'm legal to own firearms in the state right now. Because as a convicted felon, I know I'm not. But this state issued me a license. So can I go hunting here next week? Can I do that? Because they issued me a license, and it took me 10 minutes. I paid $100, and there was no question about whether I'm a felon or not. So that's interesting that I have a license here. So if we're going to hark on that, and I'm not being disrespectful.
No, I was going to ask you actually about Texas. My understanding is that, and tell me if I'm wrong about this, that your primary concern about your inability to get licensed right now relates to the licensing requirements in Texas. Do I have that right?
Federal law. So if I'm interrupt me 100%, if I'm at the time of my arrest, Massachusetts and Texas law, I'm glad you're sitting down. They're the same. We offer the same things. There's no difference in our laws. We require the same thing you guys. We just don't charge you for it. Texas has now followed the swing of the Supreme Court to expanding gun rights, and it is way more lax in Texas now. But my concern is federal law. Texas is going to follow the federal law, and I don't mean to be disrespectful, but Massachusetts does not follow the federal law. But following the federal law, ATF 4473 form is, if not verbatim, exactly the same as a Massachusetts application for a license. So my concern is that I can't own arms federally. So therefore, obviously, in Texas, I can't go into a Texas because they're going to follow federal law. So what I would say is, then here's my license. I'll submit it to the court. She has a copy, and if it's in the appropriate, Massachusetts is allowing me to hunt here with a firearm. Can I come here with guns? Because I have a license, like you brought up earlier, and this is printed from the website about hunting. It says non-residents. It says non-residents with a valid Massachusetts non-resident hunting license do not need a firearm license to possess or carry rifles and shotguns and ammunition during hunting season. So can I come next weekend with firearms and carry them around Massachusetts and tell people I'm hunting, let me know. I'm interested in hunting here. And I guess my argument isn't for criminals to own more guns. I'm not a criminal. I would say that probably 80% of this country owns firearms to stop criminals, and that's why I own firearms. I'm not trying to own firearms to kill people. I'm not owning dangerous and unusual firearms. I'm owning firearms that are extremely common. There is a appellate court case, or I think it's a Supreme Court case from Duncan v. Becerra. It's quoted in there. There's also a Jones one pending in the Second Circuit. They speak to an AK-47 and LCMs, large capacities. If we want to get into that wormhole, you could look at those cases. They're in my brief, but I will say that the DA's brief is completely fraud. These are not dangerous and unusual. Justice Brennan, you're probably right. Your hands are tied by the SJC. I get that. When I filed that stuff 2 years ago that's cut and pasted, that was for a clarification motion based on the Bryan v. Harris case, which is authored by Justice Gaziano, which is then came out to these other things. So absolutely, I'm here today, and I thank you for your time. I thank you for the court's time. But I'm only here as procedurally to try to get back to the SJC to say that, hey, this isn't right. These are legal arms, dangerous and unusual. It's not the standard. It's presumptively lawful. Sorry for going over. I thank you for your time.
Any questions?
Didn't mean to be disrespectful if it was taken that way.
Not at all.
Thank you very much. And Attorney Stern.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. As the defendant was just saying, and as I argued in that part in my brief, that the issues before him would have to get to the SJC. The issues he's raising would have to get to the SJC to have any relief from the prior decisions. I would say that, obviously our position in our brief is that Bruin has not yet changed anything that is relevant to this case. Bruin did clarify the analogical reasoning for historical purposes, which is not the same as was this literally banned in 1776, and obviously there will be litigation in the country, is ongoing litigation in the country about, how that will apply to AK-47s, but until that is fully hashed out at evidentiary hearings, at discussion, and the SJC rules on it, or the Supreme Court rules first, and then the SJC applies it to Massachusetts, that can't be applied to the defendant's case. As the SJC argued the Switchblade case on Monday, and there was a lot of discussion about, still confusion by them about what exactly they're expected to do under Bruin, but also, does it, even in that case where the issue of the history of Switchblade bans was fully briefed to a large extent, did there still need to be a remand for further fact-finding? And, all of those things may happen at some point in the future on this issue too, but on the record before this court is bound by the prior decisions in this case.
Question? Questions?
Thank you.
Anything further, Attorney Stern?
Then the Commonwealth will rest on its brief. Thank you.
Mr. Cassidy, just for clarity, I was unsure about whether you intended to submit something today, and for that purpose, what I'll say is that we will confine our review to the record, but we do have your argument. All right, so thank you both very much for your argument, and thank you for your briefing. The case is submitted, and we are going to take our recess for about 15 minutes.
All rise.
Thanks. Good morning. Okay, and calling our fourth case, Department of Children and Families and Others versus Father and Another, 22P 1131. Counsel, I'll remind you the case is impounded, and is it Attorney Fratto? Yes. Thanks.
Good morning. May it please the court. My name is Cara Fratto, and I'm here representing the appellate father today. The father respectfully asks this court to reverse the juvenile court's decision terminating his parental rights, finding him unfit, and denying his motion for a new trial. Your Honors, this case is about a trial judge who made multiple erroneous findings about a father who was ignored by DCF and he was abandoned by his own attorney. The department played a bait and switch with the child's permanency plan by advocating for the necessity of adoption at trial, but then said we had to read between the lines that it was not racing towards adoption at father's motion for a new trial. Since the trial judge used flawed findings, its conclusions were incorrect. To our first point, the trial court judge made multiple erroneous findings. We're challenging multiple conclusions of law from pages 34 to 51 in the record appendix, as well as certain factual findings of 78, 82, and 85, which are on pages 12 and 31 of the record appendix. When reviewing the evidence, you'll see the findings were clearly erroneous. While, yes, the father was incarcerated during the pendency of the case, the social worker did not meet with him. The father is arguing that the trial judge erroneously found the department made referrals for him and made reasonable efforts to service the father.
Can I pause you for a moment there, Attorney Fratto, on the reasonable efforts front? My understanding is that that argument was not raised explicitly below.
Yes, and as I raised in my brief, that I believe father is not waived from raising this argument here due to father's further arguments of ineffective assistance of counsel and constructive denial of counsel. This court has not explicitly addressed the issue of whether reasonable efforts, the issue is waived if you're also presenting an argument of the denial of counsel or ineffective assistance of counsel. The closest case that I was able to find was an unpublished adoption of Kadira issue, where that court had, the appeals court there had indicated there was an incomplete record because no motion for a new trial had been filed. So the court declined to address whether reasonable effort, the lack of reasonable efforts would be waived when there's an incomplete record with a lack of a motion for new trial. We have that complete record here. Father has filed a motion for a new trial. It was heard in the trial court. It was denied, and it's the subject of this consolidated appeal.
I didn't see an affidavit of counsel in connection with that motion for a new trial. I just wanted to confirm with you that I'm not missing it.
No, you are not missing it. I did not have an affidavit from trial counsel for that motion for new trial. I did support the motion for new trial with father's affidavit, as well as an affidavit from myself as to what I was able to, the evidence that I would have been able to, I was able to secure in a short time from representing father. From my understanding of the case law and Commonwealth v. Martinez, it's an affidavit, a failure to have an affidavit from the trial counsel is not fatal to the appeals court or the motion to new trial itself. So going back for the reasonable efforts that the trial court had found, that department made referrals. Within looking at the record for the in the trial court's findings and the evidence that was presented, this department attempted one referral for father. They attempted to refer him to, I believe it was a batterer's intervention program, and learned that he could not be referred and signed up for a program, that program, until he was released into Massachusetts with Mass Health. So they learned the same thing for an anger management referral. So they couldn't do any referrals for father until he was released back into Massachusetts. So to find that the department made referrals completely misses that they attempted a referral, one referral, and learned that they couldn't make any more. But what they didn't do is the social worker never visited the father at the jail. She had phone contact with him. She was unaware of anything the father was doing in the jail, what jailhouse programs he was doing. That begs the question of, did she even ask him? She's saying she was unaware that he was participating in any jailhouse programming. The trial court made findings that father didn't participate in programs or didn't do any substance abuse treatment, although father testified to having done it, and the social worker's testimony was she was unaware. If she's having regular phone contact with the father, it would be reasonable for her to make the effort to ask him, what programs are you doing in the jail? The trial court relied heavily on findings of father's failure to follow through with what he could do, such as signing releases or filling out paperwork for Zoom visits for him and his son. However, again, the evidence doesn't show that father ever received a release from the department. The social worker indicated he didn't sign releases, never said who she sent them to. She didn't visit him, so she didn't give them any releases in person. And
is that something, though, that the judge could reasonably infer from that by saying that he didn't sign releases, or you think that's speculative, that he was actually given something to sign and just didn't sign it?
Well, you can't, when you're sending mail into a facility, one can't assume that it automatically gets to its intended recipient.
Why not?
Well, because mail,
Any less so than if you mail it to someone's home?
if you mail it to a facility, I mean, from the juvenile judge would know that you're mailing it, it's going to go through a few levels of security. Did it make its way through there? Is there any problems at that facility where mail isn't going to the people? Is there a contraband issue going in that jail?
Whose obligation is it then to show that? I guess who has the burden on that?
Well, the department is arguing that that father didn't sign any releases. The department should at least get on the stand to say, I mailed him releases. Father was on the stand. Nobody asked him, did you get a release to sign? And so it's unclear whether father indicates he never, in his affidavit for a new trial, that he never got a release. The social worker just says he never signed them. In terms of the paperwork for Zoom visits, the social worker's testimony is she signed out a form for Zoom visits, and nothing came of it. It didn't say she sent it to father. It was up to father to follow through on that. She didn't follow up. That's on the department. The department needs to make efforts.
Counsel, without taking away from the importance of the arguments that you're making on these points, it seems to me that the thrust of the judge's concern was domestic violence, and one of the major elements of your briefing is the ineffective assistance claim. Would you like to focus a little bit on those two considerations?
Yes. In terms of, we're not just arguing ineffective assistance. We're arguing complete constructive denial of counsel by father's attorney under United States to be chronic. The standard differs from the Safarian ineffective assistance, where constructive denial of counsel here is, it's not enough for the court to have just appointed counsel. It didn't just comply with the Sixth Amendment saying counsel is appointed, counsel is at trial. The constitutional requirements is for the assistance of counsel. This attorney had very little contact with father, didn't have him participate in the pretrial proceedings. As the court docket will see, there was no indication Habes were requested for father, or that but we see multiple pretrial dates, father not being present. Unclear what the attorney did to try to secure any of his attendance at those hearings. However, what we do have is at trial itself, the attorney's conduct at trial was manifestly unreasonable. He acted as the prosecuting arm of the case and presented father in such a negative light. He was so aggressively disrespectful to the father in his questioning of his own client that there was nothing that father could say or do that was going to overcome the taint that was put out there. There was no answer that father could provide.
Was father disputing his unfitness or just the termination of his parental rights?
Father is disputing the entirety.
So going into that argument, could there have, understanding that that's the case, could there not have been a reasonable tactical decision by trial counsel to say that the unfitness component was a losing battle for father or a weaker argument, and that maybe it made sense to put all of the father's eggs into the basket of trying to maintain parental rights?
If that is a decision made in consultation with the father, then that would be, that's father's right to waive his burden, the DCF meeting the burden. It's not trial counsel's right to concede the burden. That's not a strategic decision. If he's making it in conjunction with his client, that's a different story. But here we have no indication that was strategic in nature in consultation with the father. Father indicated, and especially in his affidavit, that he wanted his trial. He wanted to maintain his rights. Father being incarcerated, incarceration alone does not automatically render you unfit. Father could still participate in placement decisions for his child. The children at the time of trial were placed with his sister. There's nothing in there. It's a placement that father had proposed, and there's nothing that indicates that the children could not be with his sister without father having lost his parental rights or without them having to have an adoption, which, again, is part of the argument here. The department was arguing heavily at trial and asked father on the stand, don't you believe adoption is in this child, your child's best interest? If adoption was not the plan, as we later found, a month later, department came running back to the court to seek a home study of the mother for a reunification because mother had been doing so well and she had been in compliance with everything. This is a month later of having them find her unfit. And then the DCF attorney arguing, well, we weren't racing towards adoption, but they were arguing at trial, adoption is necessary, asking father himself, isn't it in your child's best interest for him to be adopted? And again, his attorney letting all that in, denying him the right to have a fair trial, not subjecting the DCF's case to a meaningful adversarial process, not objecting to the fact that don't you think it's in your child's best interest to be adopted. That's an objectionable question, should have been made. An attorney that was acting as an advocate for their client rather than as somebody for the prosecution side would have objected to that. Making arguments against your own client, to your own client on the stand, that is denying your right, the client his right to counsel. His attorney objected to his own exhibits at trial. I mean, that's crazy to think that you're advocating for your client. You've got to introduce evidence and then say, well, they're hearsay. That's not advocating for your client. That's basically, as the Chronic would say, you're basically throwing an unarmed person to the gladiators. So what we're arguing here is that this attorney so utterly abandoned his own client that father here would have been better off without an attorney. It's not enough that this court just appoint counsel and say, we've complied with the appointment of counsel. The counsel needs to provide assistance. It needs to be effective. And so under Chronic, the issue is that no prejudice is required. Now, reading the Department of Child's briefs, they're relying heavily on Safarian. And while they are both cases on the same spectrum on effective assistance of counsel, one is assuming counsel was there and just was simply ineffective, and effective assistance wouldn't have changed everything. Another is assuming this client rather, was denied counsel to the extent that they either didn't have an attorney or they would have been better off without an attorney. So in arguing here, we would ask that you apply United States v. Chronic in this situation.
Do you have a case applying the Chronic rationale to a civil matter?
Well, not in Massachusetts. In Massachusetts, there was a case of, I believe it was adoption of Olympia, another unpublished decision where the appeals court there declined to consider her Chronic argument because it wasn't raised in her brief and it was raised for the first time on appeal. And they had said that her real claim was ineffective assistance. However, within Kansas, there's in re Rushing. It's 684 P2D 444, where it says Chronic was applied in that termination proceeding for child welfare. Also, a case of in re VV, a minor child, which is 349 Southwest 3D 548. It was a Court of Appeals case in Texas, which also held that Chronic was at one end of the continuation of the Strickland cases, and it applied in that particular termination proceeding. Ultimately, the father in that case had lost on that issue because they didn't feel that his attorney utterly failed in subjecting the prosecution's case to a meaningful adversarial testing. And I would argue that this case, it does. Father does show that in here.
Thank you. Questions? Thank you very much.
Thank you.
Attorney Frisoli, you'll be arguing for 10 minutes and Attorney Stern for 5, is that correct?
Correct.
Thank you.
Thank you, Your Honor. May it please the Court, my name is Carol Frisoli, and I represent the Department of Children and Families. Before the trial court,
was overwhelming evidence of father's unfitness, which included a decade of domestic violence between mother and father, an extensive criminal history, and subsequent incarceration of father for violent crimes, including attempted murder against the mother, an extended period of no contact between the child and the father, where the child at the time of trial was refusing to visit with the father and had not had a visit since August of 2021, and the father's failure to address any of these shortcomings in services, and father's incarceration at the time of trial with no set date of release. The record in this case is primarily not challenged, with the exception of the findings of fact that my sister referenced. The trial court found that father had engaged in such a decade-long of history of domestic violence with the mother, with the most recent incident occurring in 2021, where the father punched the mother at the beach, shoved her face in the sand, and attempted to hold her face in the sand and water at the shoreline, which was all viewed by the public. There were multiple incidents during this relationship between mother and father of domestic violence while this child was present, including mother falling down the stairs and breaking her arm. At trial, father testified that he had no understanding of how the domestic violence affected his child. In fact, when he was questioned by the department's attorney about the impact that domestic violence could have on his child, he said it was due to his relationship with the mother. He took no responsibility for the violent acts and the violence that he displayed with his child. And that was all during testimony under the department's, during the trial.
So, counsel, if we assume, I'm going to ask you to assume for a moment that as the father maintains in his affidavit, he was not prepared by counsel to testify at trial. Is there a remedy for that at this point, or does that lead us into what your sister argues is sort of a denial of effective counsel? In other words, I don't dispute that the record reflects that he gave the answers that you are reporting on, but to what extent do those answers reflect an inadequacy on the part of his counsel if he was not prepared?
Again, these issues were litigated in a full-fledged hearing before the trial court with the motion for a new trial. The only evidence was a self-serving affidavit of the father stating that he wasn't prepared. Again, never raised an objection during the trial about his attorney, didn't seem to have any dissatisfaction with his attorney during the course of the trial. I mean,
but is that required? I mean, does he have to stand up and say, this guy is malpracticing me?
No, but it goes to, at the end, when the results are against the father then prepares an affidavit and says, oh yeah, by the way, he didn't prepare me. Again, the trial judge in this case heard these arguments. They were extensively briefed by both the department and the father's attorney. There was a full-fledged hearing, and the trial judge's decision was that the questioning of the father was a strategy on the father's because of the overwhelming evidence of unfitness in this case. Again, there is nothing that has been presented by the father which shows that it would have ended up in a different result. We have no offers of proof here that say, hey, by the way, if I had, been better prepared and I didn't, answer. Again, at the time of trial, the father was questioned numerous times about the domestic violence, which was the major issue in this case. And father numerous times stated that he blamed the relationship and during the course of the case had sent letters to the child saying that him and the mother were going to be together. He didn't benefit from any of his maybe potential services. Again, that's where the the father stating, that he wasn't prepared, he testified himself. It was from his own words, and that's where the trial judge made that a fair conclusion that, based on father's own testimony, that he didn't benefit from any of these services or have any understanding of the impact of domestic violence on his child.
Sorry, go ahead.
Just one more question. If we were to ignore the challenged findings and conclusions, what is the department's position about whether the record would still be sufficient to support this termination decision?
Again, the findings and conclusions that are challenged are based on that the father did not learn anything from his domestic violence. That was one of the findings that's concluded. That was based on the father's own testimony. The judge made that conclusion. The second finding was about that the father didn't engage in substance abuse. Again, the father said the only time he was violent with the mother was when he was under the influence of alcohol.
So are those findings and conclusions necessary to the judge's ruling?
Number one, they're not erroneous, but even if we took the hypothetical that they were clearly erroneous, the other factors, the other overwhelming factors of unfitness in this case, again, father was incarcerated in New Hampshire. He was not available. He had done nothing to address the domestic violence, his extensive criminal record. He had never been the primary caretaker of this child. All of these factors were part of the judge's decision in both finding the father overwhelmingly unfit and as well as terminating his parental rights. So there were multiple other, these two not signing, not being provided a release or what have you, that was not a factor here in the overwhelming evidence of this father's unfitness in this case.
So understanding that you do not concede ineffectiveness, what is your position on the application of the law as it relates to deprivation of counsel to this sort of a case?
Again, the case cited is based, it was a real estate attorney that on a criminal proceeding. In this case, it's again, this is a civil proceeding, and in addition to, again, not conceding on that it wasn't ineffective, which the trial judge found after a motion for new trial, this wouldn't apply. This is a civil case where, again, we still have been nothing offered about even if you don't get to prejudice, what if this father had, say, represented himself and not, there was no attorney here, what evidence would have changed this result here? That's where we ultimately get to, and that's why the standard is much higher in a criminal case where you're talking due process, and not that you're not talking about due process in this right, but we're talking about liberties, this is, again.
Some of the same standards apply, though, right, as relates to removing a child from a parent as in criminal cases.
Absolutely, absolutely.
There are analogies there.
There are analogies.
On other types of analysis. Why not this one?
Again, in a care and protection case such as this, where, again, sometimes parents do represent themselves, the conduct here of the attorney, when the evidence is so overwhelming, such as in this case, about the father's unfitness, and in fact, unavailability. The father himself testified, or what the judge found, that the father could not take this child. He wasn't looking for custody of this child. He just wanted to, which was noble on his right, he wanted to fight for his son. But again, he had no plans in order to take custody, or he just didn't want to, he wanted to fight for his son and but didn't, as the trial judge noted, it was almost selfish on this father's right, where he had no plans to take care of or become the caretaker of this kid, just not to interfere with the child's permanency.
Well, I mean, it's not, it's legitimate for a parent to want to retain a legal relationship to his child, even if he recognizes that he's unable to care for the child in the present moment, right?
Absolutely. And that's why I'm saying that the judge noted that that's a noble intent. But the reality is here, this is a child who needed permanency. And the father, in this case, had never really been the primary caretaker. He had spent the majority of this child's life either in prison or in a very violent relationship with the mother and exposing this child to trauma. So again, given, especially with the domestic violence, where the father didn't show any kind of remorse or any kind of, that he benefited at all from understanding the impact of domestic violence. In this case, it was really relevant to not have this father have parental rights with this particular child.
Thank you very much.
So again, if there is...
Now I just have to stop you here, Attorney Frisell.
Okay,
Thank
certainly.
you very much. We have your...
I would rest on my brief. Thank you.
And Attorney Stern.
Good morning. May it please the Court. My name is Craig Stern on behalf of the child in this matter. The trial court's decision to terminate father's parental rights as well as deny his request for a new trial should be affirmed for 3 reasons. First, his unfitness was due to a long history of alcohol abuse, criminal activity, domestic violence, untreated mental health issues, and a lack of insight, as my sister pointed out, into how this would affect his child. His attorney's performance, second, was not measurably below that of an ordinary fallible lawyer. And third, the child's placement post-termination is not relevant, as the trial court declined to order any contact between father and child in this case.
Does the fact that the permanency plan changed after the termination trial concluded provide any additional basis for the father to seek contact now?
Well, that was the hope that the termination would then prevent that. So if the department would be looking at some point to reunify with the mother, father would not be able to flood either the juvenile or probate court with motions seeking visitation. It essentially cuts him off, as the child's position in this case was to have no contact with father. At the time of trial, he hadn't seen him for about a year. So he doesn't want him in his life, didn't want him in his life, and that has remained the same since.
The child was 12 at the time of trial, is that right?
Correct. And he's 13 now. So as to my first point of the termination, as stated, father acknowledged he was not fit at trial, does not dispute this fact on appeal. He was incarcerated for almost the entire case. His criminal record is extensive. He has a 15-page carry. The lengthy history of domestic violence with mother and other women as well. Mental health concerns, substance abuse issues, and was not able to reflect on any of these issues at trial. He didn't deny the unfitness. He wasn't asking for custody or placement at the time of trial. And when asked about the goal of adoption, he said he supported it somewhat, simply just asking for his parental rights not to be terminated. Those were his words. That was his testimony. That was his testimony under examination by the DCF attorney. Father's attorney cannot testify for his client. Those questions came from the DCF attorney. The judge in this case called his desire to keep his parental rights selfish because it was to prove a point to show he's a good father, not because it's in the child's best interest. Even though he had years to show himself as a capable father, which he failed to do, he wanted to keep that title without any of the parental responsibilities, but his history shows that the unfitness will continue undiminished into the future to the child's detriment. As to the second issue of ineffective assistance, father can't meet the 2 prongs under the adoption of a Ziza case, which is on point in terms of ineffective assistance of counsel. First, he must have shown his attorney's performance fell measurably below that which might be expected from an ordinary fallible lawyer. And if so, his counsel's conduct had likely deprived him of an otherwise available defense. Second, prejudice must be shown. Prejudice is not shown if there's overwhelming evidence of unfitness, which is the case here. In Aziza, the evidence of unfitness was sufficient, but it was not overwhelming. Father's trial counsel, while unsuccessful, did employ a strategy to undermine, combat, or explain DCF's strategy. When strategic choices at issue, tactical decisions only amount to ineffective assistance of counsel if it's manifestly unreasonable when made, and that's under Aziza. Father's counsel was facing overwhelming evidence of father's unfitness, and he chose the strategy to address the evidence head-on by allowing father an opportunity to straightforwardly plead his case. There was no additional evidence, documents, witnesses that would have changed the outcome. There's been no suggestion from father as to what strategy would have worked in this case. There's no affidavit other than father's self-serving affidavit on his motion for the new trial, or any offer of proof whatsoever of any additional witnesses as to what would have been testified to, including the New Hampshire prison caseworker that would have potentially supported father's position. There was no affidavit from this individual. As to the second prong on the issue of prejudice, it must be shown. It's not shown if there's overwhelming evidence of unfitness. Here the trial judge was explicit in that the conduct of trial counsel did not meet the level to eliminate the need of a showing of prejudice to warrant a new trial, and refers to the evidence against father as overwhelming not less than 4 times, stressing the magnitude of his unfitness, which would continue into the indefinite future. Trial counsel tried to get his father to address his shortcomings, and the strategy failed because father simply had not learned from his mistakes. Finally, father, I see I'm out of time, so if there's any questions, I'll rest on my brief.
Thank you. We do have your brief.
Thank you.
Thank you all very much for your excellent briefing. Thank you for your arguments. The case is submitted. And our 5th case today, James Moretti versus Laurie A. BRUMGARD, 23P0569.
Good morning. May it please the court, my name is Eric Stafford. I represent the appellant James Moretti. By way of a little background on this matter, at the core of the case is really the ill-defined and inexact nature of when couples in long-term relationships come to the end of the road and they wonder how to divide the assets. It's very common, of course, that hope springing eternal and love also being eternal, that these issues are hardly ever dealt with at the beginning of long-term relationships. And at least the processes and practices that have been employed in the probate court as to married couples, well, far north of perfect, or a model of grace and fairness when contrasted with the claims and causes of action that non-married couples have to assert in order to, find some relief in the superior or the district court.
Could that be explained in part by the fact that entering into marriage is an agreement between the parties to have a legal relationship with each other that leads to other agreements that can be either inferred or understood?
Yes, I agree with that, Justice Hershfang. That's exactly right. And it's the reason that we are here, the issues that are here on appeal is what the elements in the burden of proof are regarding unjust enrichment, which at its core is a remedy that looks backwards almost to see at the entirety of the relationship and whether to allow one person to keep the assets would be unjust or unfair. It's akin to restitution. The claims that revolve quantum merit are much more suitable for when the painter forgets to write up a contract, but he expects to be paid, and the homeowner expects to pay him, but the certainty of a contract are not defined.
Should we take it from that, Mr. Stafford, then that you're not really challenging the quantum merit, that there really wasn't here an expectation of payment per se?
Right, exactly right, because I believe that if there was a viable claim, as I said, it was stated in the alternative. If quantum merit was provable, there would be a legal remedy available, and unjust enrichment would not be available because it only is available when you are lacking a legal remedy. So if, in the circumstances of this case, by adding we assert adding the extra element of that Mr. Moretti needed a reasonable expectation of compensation in order to prevail on either claim, if he were able to carry that burden, he would have a legal remedy, and unjust enrichment would disappear into the ash bin of history.
Is it your position then that the expectation of the parties has no role in an unjust enrichment claim?
I think that it is an element of how a remedy is fashioned. I think you need some guide as to what the parties' beliefs were.
So I'm reading from Bonina versus Shepard.
Exactly.
Where it says whether the benefit was unjust turns on the reasonable expectations of the parties. So what else could we read into that other than that to prove an unjust enrichment, you have to look at the expectation of the parties and see what they were?
Well, in this case, Justice Breyer, that at the end of the relationship, if someone asserts that, we've lived together in this house for 10 years, it's in your name, but, I've paid the mortgage, I've made improvements to it. If someone were to assert that, whether or not the reasonable belief, reasonable expectation is a question that goes to the jury, and they can, it's this unjust enrichment claims are kind of the second cousin of loss of consortium claims. I mean, juries are very skeptical about them. In order to win an unjust enrichment claim, I think carries a pretty, you've got to demonstrate a pretty good case to a jury.
In this case,
but that is in practice. I'm sorry.
I'm sorry to interrupt you, but in this case, would the jurors, if the unjust enrichment claim went to them, have to compare, in order to determine if there was actual enrichment, the input from your client versus the benefit that he received from the opposing party?
Yes, I think that is always going to be a play, because the unjustness of the result often it just comes, it evolves over time. It's not nobody's fault this happens. It just one person ends up with everything, other one ends up with nothing. And is that a fair, resolution in the context?
It may not actually matter, but is the fact that there is evidence in the record of what, for example, the mortgage payments were on the homes in which the parties lived at different times, and as far as I can recall, and correct me if I'm wrong, there's evidence of a difference in the home sale price, but not necessarily any specific information about the value of the improvements that your client made to either one of those homes. Am I correct so far?
Yes, I think that would be, it's the evidence that is presented to the jury for them to decide whether the result at the end of, whether unjust enrichment occurred in this case, and they could find that it did not.
But is there, using the math, using the record that we have, is there math that any fact finder could do that would permit a finding of enrichment by your client?
Yes.
Sorry, enrichment by by the opposing party.
Yes, because there was evidence that was presented to them of just the evidence that we put in, that there was equity, and I understand that it wasn't, to the certainty that an expert would provide, but at the end of this relationship, the pot for her was much bigger than the pot was for him, and the jury could evaluate whether the improvements and the mortgages added up, and find that there wasn't an unjust enrichment here, but we'll never know because it didn't go to them.
Your client, I'm sorry, go ahead.
Just to follow up on Justice Hand's question, my memory, and numbers are not my strong suit, so my apologies if I get this wrong, but my memory is that the defendant had testified that she had spent something like $450,000 in mortgage payments, taxes, and home insurance on the two homes during the time that the parties were in them together, and that your client testified that for 7 or 8 months early in the relationship, he had given her $1,000 per month for a total of $7,000 to $8,000 for housing costs. If I'm wrong about that, please tell me.
I don't remember that 450. I don't have a specific memory of that, but it seems high to me, yes.
It seems high to me, too, so maybe I'm wrong. But in any event, I think the evidence was undisputed that your client lived in these homes for 7 to 8 years and paid a total of $7,000 or $8,000 in, I'm going to call it rent. He says it was given toward the mortgage, but housing costs. If those are the facts before the jury, how can they find, and I'll add in that my review of the record was that all of the expenses, I'm putting aside the value of his work, but all of the expenses for the materials for the renovations were paid for with her credit cards. So at the end of 7 or 8 years of that, I don't see how under Bonina a jury could conclude that she had been unjustly enriched.
Well, in the light most favorable to Mr. Moretti, which I think is the standard we have to apply here, there are also factors. While she paid the mortgage, she also got to deduct the mortgage interest. She ended up with all of the equity in the property.
Well, she put in all of the down payments for the property, and they were held in her name.
No, we're not disputing legal title. We're not saying that he owns half the property. We're saying that she owns the property. If, by way of analogy, if my girlfriend and I put in a refrigerator and a deck on the back, and we split it, and I'd like to be reimbursed as a rule of, improvements in real estate, it's a universally accepted idea that you're going to be, you're going to be reimbursed for improvements that you make on somebody else's real property.
What evidence did your client put in regarding the value of his contributions, the expenses that he paid, anything at all that would actually give a monetary value to anything that he did or contributed? If it's there, I did not see it, other than the 7 to 8 months of $1,000 payments for which he had no receipts or canceled checks or bank records, to which Justice Hershfang referred.
Right. There was a dispute of whether, that the evidence was that she said she paid for all the materials with her credit card. His testimony was that he reimbursed her. She wanted, the miles and the benefits from paying with a credit card, but he gave her the money back. She disputes that. Jury question. In terms of the value,
can you point to, I may have missed that in the record. So that's somewhere in the record that he says he reimbursed her for the credit card payments she made for the building materials, if you will. Okay.
Yes, that is correct, Your Honor.
Okay.
Is there a dollar amount associated with that? I don't recall that.
No, I don't think that it was in the same way that he didn't say that, the retaining wall that I built is worth X, because, he had a background in construction, but not to the, like Benita's a great example of, that is someone that did it for a living. He knew how to do invoices, and he certainly knew how to present evidence to the court as well. James Moretti's proof is, if you will, in the pudding. And I understand that it's not, it gets mixed in with the passage of time and how real estate appreciates, but it's not whether or not that the contribution, his contributions, are provable to a jury is certainly, I don't think that you can say at the end of the evidence there's no possible way that any jury anywhere in the world could find that this is an implausible claim.
Well, it's a reasonable jury, right? Not just any jury anywhere in the world. All right, fair enough. But let me ask you this then: what was wrong with the judge considering your client's testimony more than once? Well, that I did this out of love. That it wasn't for compensation. It wasn't because I expected anything other than we were in love and we were joined at the hip, et cetera, et cetera. That's his testimony about his
Because I think that if there's no a pre-relationship, writing, akin to a prenuptial agreement, that issue is always going to arise. We do things for the people we love because we love them, but it doesn't mean that the result.
Right. But he could have said, well, I loved her and I did it because we were in it together, but at the end of the day, I expected that when we sold the house, I was going to get my cut out of it. He never said that.
Well, there was testimony where they had conversations. He testified that along the way, she said, well, if I had to pay you now, what would it be? And his testimony was $100,000.
Was that along the way, or was that at the end, after the end of the relationship, when he was trying to get some money and there was trying to, it was during it.
Still playing nice. It was at a dinner that issue came up, and it was. I don't believe it was after she moved to Canada or to the Canadian border for Homeland Security. I think that it was just a dinner conversation, say, halfway through their relationship. The quantum miracle claim, like I said, if he was able to meet that burden at trial, that he had a reasonable expectation, and she had at least the idea that he wanted to be repaid and accepted the benefits, then he would have a legal remedy and the unjust enrichment would not lie. And the rest, I'd just be glad to spin in the briefs if you don't have any questions.
Thank you very much.
Thank you very much.
May it please the Court, Mark Horrigan for the defendant appellee, Laurie BRUMGARD. I would submit that if you examine the trial record under any objective standard, no reasonable juror could find that there was a reasonable expectation of payment, that Mr. Moretti, by virtue of the fact that he lived rent-free for at least 77 months in these properties, that established that he was fully compensated for whatever services he provided. And there's nothing in the record to establish there was any injustice, any violation of fundamental principles of equity or good conscience. If you contrast it to the Bonina decision, there's a very stark difference. The judge's question earlier as to whether there was prima facie evidence that Ms. BRUMGARD expended roughly $450,000 during the time they were living together to put a roof over Mr. Moretti's head. That is in the record. I can give you the citation if you want it. She testified he lived in the two homes she owned for 8.5 years without paying a cent in rent. He testified he paid $7,000 or $8,000 via checks from his mother.
So we pretty much, for the purpose of what we're doing here, we need to assume the $7,000 or $8,000. Fair? Since it's got to be in the light most favorable to the plaintiff.
If you assume 77 months he lived rent-free, that's based on his testimony alone.
But the $7,000 or $8,000, we have to give him that.
Yeah.
We looked in the light most favorable
I'll
to the
concede
plaintiff.
that,
Okay.
whatever it's worth.
Could I ask Mr. Horrigan, just while you're on a break for a minute, do you take the view that it appears the judge took that the expectation of payment is the same thing as an unjust enrichment?
I would submit that it is, Your Honor. If you look at the case of Solomon versus Terror, it's an SJC case, 1985, 394 Mass, 857. At 859, it boils it down. It says the injustice of the enrichment or detriment in quasi-contract equates with the defeat of someone's reasonable expectations. And they cited Corbin on contracts and cited a particular section. I think if you look at that opinion further, it basically says, as the judge found in this case, the two counts, unjust enrichment and quasi-contract, are indistinguishable in terms of the essential element of a reasonable expectation of payment.
So what do you think the difference is, if you had to identify a difference? if you want to suggest to us the difference, what is it between the two claims or causes?
In quasi-contract, I would submit there has to be something akin to, if it's not a full agreement, an agreement. And if you go back to the record, Mr. Moretti basically acknowledged on cross-examination that he could not recall any conversation, could not produce any writing with respect to any form of an agreement as to that he was going to be compensated for whatever he did. So I don't see under those circumstances you can find an implied in fact contract, if you will. Moreover, there was substantial evidence during the trial that he was in substantial financial distress throughout a large chunk of the period they were living together. He was unemployed for 15 months. He was unable to pay anything toward credit cards, and he was in Malden District Court on collection matters for several years.
So, Ms. Horgan, assume for the moment that we give you all that, and all we have left, perhaps, is his contributions to the home or homes in terms of the work he put into it and the renovations that were made. Why is it not a jury question to do the math?
There's nothing to boil down the value. There's no prima facie evidence as to the dollar value of what he paid out of pocket.
So he would have had to say at least, well, the patio or my labor on the patio was worth at least $5,000, or my labor to do the kitchen cabinets, excluding what the subcontractor did, my portion of it was worth X amount of dollars. You're saying that's required in some way?
It's left to rank speculation, so a jury couldn't find anything based upon it, or it's totally outweighed by what he received in terms of property. 77 months of rent-free living. Part of the time, she's living in Toronto. He's living alone.
So part of your is that the scale is so completely unbalanced that no reasonable juror could possibly come to the conclusion. Is that what it is? Is that your primary argument, or is it more that he didn't supply any evidence that of the value of what he actually contributed, or both?
I don't think it's mutually exclusive.
What do you say about the argument that Mr. Moretti makes that the change in the value of the homes is the amount of the contribution that he made?
There was no competent evidence that any appreciation and value was due to whatever he contributed by way of services. He admitted on cross-examination that property, as we've seen in recent years, can escalate for reasons that have nothing to do with any renovations that were done to the property. So that would be, rank speculation as well. There was nobody that offered any competent opinion or facts that showed whatever he did added to the value. And as Judge Brennan pointed out, he testified that he did all this out of love, so there was an element of donative intent.
But does that matter if in the end analysis you may have intended that at the time that you did the work in Mr. Moretti's shoes, but when the relationship falls apart, is the question for the judge on an unjust enrichment claim then not whether there was an expectation of payment at the time?
Well, how is it unjust?
Whether the enrichment at the end of the day, whether it was unfair to allow Ms. BRUMGARD to benefit if she did.
How is it unjust if you did it unilaterally or volunteered it and did it out of donative intent? I mean, how does it violate your conscience, principles of equity? And again, whatever he did was far outweighed by ISOMIT, by the benefits he received. So no, there was nothing in the record to the contrary. No juror really could find anything different. And I submit the judge's assertion that a reasonable expectation of payment was an essential element of this case is well-founded if you look at Solomon versus Terra. And There's nothing in the other cases that rules that out. And this is in stark contrast to the Bonina case. In Bonina, you had hard and fast evidence regarding what was paid out. It was over $150,000 by the plaintiff. That's the only case that I can find where this type of claim was upheld on appeal. So I submit that it should carry some weight. With respect to the conversion claim, there's nothing that the plaintiff produced that warrants reversal of the jury's verdict on that count. The substance of the evidence that was produced was he had ample opportunity to pick up this tractor and refused to do it for whatever reason or failed to do it. And I submit that under Poirier versus Plymouth, the judge was completely justified in directing on this case. Otherwise, I'd rest on my brief.
All right, thank you both very much. Thank you for your briefing and thank you for your lucid argument. That concludes our sitting today. We'd like to thank the court officers for their help today, for the law clerks and our recording law clerk today. Thank you very much to the members of the clerk's office and to our technology specialists. And we are adjourned.